This video is designed to help you understand the legal framework of advanced care planning, including enduring powers of attorney for personal care and welfare and advanced directives. Advanced care planning is a process of shared discussion for future healthcare. It involves an individual, whānau, and their healthcare team. Advanced care planning is an opportunity for a person to develop and express their preferences for future care based on their values, beliefs, concerns, hopes, and goals. The focus is on giving people the opportunity to say what care and treatment they do and don't want now and in the future, as well as what they would like to see happen when they are dying and after they die. The person is encouraged to capture this in an advanced care plan. This plan is aimed at supporting people and their families to get onto the same page about what is most important to the person and to ensure their healthcare team use that information to support shared decision-making in the future. It can help a person and their whānau clarify differing views, improve understanding of treatment options, feel more in control, and positively enhance a person's hope in the face of progressive illness. Advanced care planning has also been shown to reduce stress, anxiety, and depression for whānau after a person has died. For healthcare staff, the process of advanced care planning helps to develop and deepen relationships between a healthcare team, the person, and their whānau. Evidence shows that advanced care planning supports a substantial reduction in unwanted and unwarranted treatments for people. This leads to fewer and shorter hospital admissions and improved quality of life for the person in care. Ideally, this process of planning starts before the person becomes unwell and continues throughout their lifetime. An advanced care plan has a section for a person to say who they want to be involved in decision-making. People named in the advanced care plan will be included in conversations about what care and treatment to provide wherever possible by the healthcare team. These people will not be able to consent or refuse treatment for the person unless they are the person's activated enduring power of attorney for personal care and welfare. Enduring powers of attorney for personal care and welfare cover the person's health, accommodation, and associated care decisions. There can only be one person designated for this role, and the responsibility is activated only if a medical professional or the family court decides the person is not competent, as defined by the Protection of Personal Property and Rights Act of 1988. The overriding consideration of the attorney is to promote and protect the person's welfare and best interests. They can make decisions on the personal care and welfare matters only as specified in the EPA and the Act. But there are limits on the attorney's powers. The attorney cannot refuse consent on behalf of the person to have medical treatment that might save their life. If a person has a strong preference not to receive a specific life-sustaining treatment, they should capture that in an advanced directive so that the person's attorney will not need to be asked to consent. An advanced care plan has legal standing, and clinicians are required to take it into consideration when determining treatment options. Rights and corresponding obligations for clinicians are set out in the Code of Health and Disability Consumers' Rights. These include the right to dignity and independence, the right to services of an appropriate standard, and the right to make an informed choice and give informed consent. An advanced care plan can and often does include an advanced directive. An advanced directive is consent or refusal of specific treatment that may be offered in the future when the person no longer has capacity. It doesn't come into play until the specific treatment is offered and the person is unable to consent themselves. Advanced directives are generally valid when they are created by a person who has mental capacity to make the directive is made freely and without undue influence. The person intends to apply it to the current circumstances and, at the time of making it, the person understood the benefits, risks, and consequences of consenting to or refusing the specific treatment. Valid advanced directives are legally binding. This applies even if a refusal of treatment contained in the advanced directive is not what is in the person's best interests from the clinician's perspective. Just like when a person is competent and refuses a treatment, we cannot force the treatment onto that person. An advanced directive does not need to be signed or dated, and in fact can even be verbal. However, having an advance directive in writing, signed and dated by the person and the supporting clinician is good practice. The National Advanced Care Plan template contains a section for advance directives. Providing the directive as part of an advanced care plan will give the clinician more information and context to understand the advance directive and assess its validity. Depending on the situation, there are a series of steps to offering treatment and seeking consent. First, a treating clinician determines what treatment to offer based on the person's current condition, other health issues, and risk. They take into consideration the person's goals, priorities, and preferences. Ideally, the person has captured this information into their advanced care plan. Just because a person has requested specific treatments or stated a treatment preference does not obligate the treating clinician to offer these. If the person is able to, they will be asked to consent to the treatment offered before the clinician proceeds. If the person is unable to consent, then the treating clinician should determine whether the person has already consented in the form of an advance directive. If there is a valid advance directive that applies to the specific treatment offered, the consent or refusal contained in the advance directive is legally binding. If there is no advance directive, or the treating clinician has reasonable grounds to doubt the validity of the advance directive, the clinician must look for anyone else who has the power to consent on behalf of the patient. This would be an activated enduring power of attorney or court-appointed welfare guardian. It's important to know that no one else has the legal right to consent or refuse treatment, and that an enduring power of attorney cannot refuse life-sustaining treatment. If there is no one with the power to consent on the patient's behalf, the treating clinician is obligated to take into consideration any advanced care plans and talk to whānau and other clinicians about what the patient would have wanted. If the treating clinician is unable to ascertain what the person would have wanted, then they will need to make the decision for the patient based on the patient's best interests. This legal framework focuses on individual decision-making and autonomy. It does not support collective decision-making. So, in summary, it is ideal if the advanced care plan is documented in the National Advanced Care Plan template. This increases the chances that what matters most to a person and their whānau is used to direct their care now and in the future. In this advanced care plan template, a person can communicate what matters most to them and what worries them, why they are doing an advanced care plan, how they like to make decisions and who they want to make decisions on their behalf, what they want when they are dying, what they would like to happen if they cannot communicate for themselves. Any advanced directives, including refusal of life-sustaining treatments, their wishes after death. It's best if an advanced care plan is completed with the support of a clinician who also signs the document. The advanced care plan can then be shared with whānau, the enduring power of attorney, and the healthcare team. A copy should also be available in the medical record so it's easily accessible, and it can be reviewed when there has been a change of circumstances. An advanced care plan does not need to meet any of these criteria to be useful, but it will be easier to use if it does. The process of creating this plan is a benefit for individuals, their whānau, and their healthcare team. It can help everyone navigate the legal framework of care when a person is unable to communicate for themselves.